Good morning, everybody all across South Africa. Seeing people signing in the chats. Very, very warm welcome to this edition of the Family Law Roundup. This month's roundup looking at October 2024. Very, very excited to share with you some of the interesting developments in our law during the last month, and some very, very interesting cases that we are going to be going through. So let's get right into it. We have 27 judgments to get through this morning, folks. So I'm going to be running at a fairly brisk pace. Nadia, I see that you are still in the studio in the background. I've received a few WhatsApps from people saying they are struggling to come in. If I can just ask you to distribute the links again on the various WhatsApp channels for those who need to get in. For those of you who are joining us for the first time, the format of the presentation is essentially that we take a look at the significant case law in family law for the past month. We summarize said case law and I share it with you in 90 minutes or less. Obviously, as you can imagine, going through 27 cases in 90 minutes means that we are going to have to fly at the speed of light. I don't have time to go into detail on all of these cases. However, it is important that you be made aware that these cases exist and that you know where to look for your pressing questions that need to be answered in respect of family law matters. So as we go in, a reminder, please go and have a look at thinklegal.coza. You can register for events, join our free WhatsApp groups, the family law group and the commercial law group, as well as our events notifications. You can purchase resources and you can view past webinars. The links to our YouTube channels, etc., can be found on our website. For those of you who are not yet on the WhatsApp groups, please go to thinklegal.co.za. The commercial group and the family law group are open only to industry professionals, and the people that join those groups are put through a very brief vetting to make sure that there are people within the industry. The event notification group, however, is open to anyone, and you can join the group by going to our website and following the link. We share not only our own events, but also industry events by other organizations. Thank you, Nadia. I see that she has posted the links in the comments for us. So, guys, what is Think Legal? It's an initiative by Family attorneys. We aim to promote the open sharing of sound legal knowledge. Obviously, while delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. Following along with this ethos, we facilitate open dialogue on our WhatsApp channels, where we also share legal knowledge among professionals, and we also organize a variety of events which have not happened for some time, but which we are furiously busy planning for either later this year or early next year, depending on the interest and availability of people to attend. Right. Finally, as we go in, special thanks to obviously Family attorneys who are very, very patient with me as I give my time to present the roundup, and then Lawbox practice management software by lawyers for lawyers. Try Lawbox for free for 14 days. Go to lawbox.co.za. No contracts, downloads, or hardware required. So as we go into the roundup this morning, my reminder to you, if you would like to follow along on our summaries, which look a little bit like so. Today's summary is 26 and a half pages long of our 27 cases that we're going through. In our summaries, I give you the citation, the judge, the court, a brief overview of the case, what is covered, the outcome, and some notable quotes. This you can purchase from our Shopify store for the eye-watering amount of a mere 250 rands, and that will also then get you the bundle of cases that we refer to in the roundup. If you are a member of SARM or Social Justice, or any of the NABFAM bodies, in essence, you also get a certificate for 2 CPD points for attending today, alternatively watching the live or the stream at a later stage, and purchasing the resources. Special thanks to Atlegang Messi for helping me to prepare these summaries and undertaking the mammoth task with me every month to make sure that we have our tables and summaries prepared. If you are not inclined or unable to purchase the course pack, you are still more than welcome to attend the session this morning, absolutely free of charge, with no obligation, and you are most welcome to do so. Having these summaries and the bundles open in front of you, however, will certainly enhance your experience and make it a lot more useful to you in your practice. So Nadia is going to post the link to our Shopify store shortly, or perhaps I might quickly share it myself since I've got it open. Let's see if she's beat me to it. Yes, she has beat me to it. Oh, done. Sure. For those of you who'd like to pick up the course pack, go to Shopify, pay with credit card, and you get the course pack. If you are somewhat old school, like I can be sometimes, you are welcome to pop me an email. You'll see my email address right at the bottom of your screen, mervin@familionlaw.co.za. Ask me for the course pack, and I will gladly email you the course pack and our banking details to make payment. It is a great way to support what we do and make it feasible for us to run this session every month free of charge for everyone who would like to attend. So, without further ado, let's get into it, folks. I've divided the roundup into 3 parts this week simply because we have so many judgments to get through. It is simply not feasible for us to do a slide for every judgment. It would have taken us very, very long to prepare the slide deck for today. So I went and I listed all the judgments, and I did beautiful animations that the names flew in and flew out and all the rest. And unfortunately, StreamYard said, absolutely not. We are not going to give you animations on your slides. So you will see everything on your slide as we go now. Part 1, we are going through the first 2, 4, 6, 8, 9 judgments, and I will run through them. Please follow along on the slide or in your course pack as we go through. The first section we're going to deal with today, our first 5 judgments, deal with the aspects of divorce, and we are, for the most part, in Pretoria, and then we have 1 judgment from Mbombela, as you can see per the citations on your screen. The first judgment we're going to be looking at, folks, is OKM versus LPM and others. Your citation, as you can see on the screen, ZA GPPHC 982. This is under the pen of Nyati J from the North Gauteng High Court. Those following along in their summaries and in their bundles, please page to page 1, and you will be able to follow along as we go. The matter of OKM versus LPM dealt with an interdict of the sale or transfer of immovable property in the context of divorce. In this instance, the applicant sought an urgent interdict to stop the first and the second respondents from selling or transferring the matrimonial home. What was very interesting in this instance is that the matrimonial home was allegedly registered in the second respondent's name, not the spouse's name, to conceal, according to the applicant, the first respondent's true ownership of the property. So what was covered in this judgment were obviously the requirements of an interim interdict being a prima facie right, well-grounded apprehension of irreparable harm, balance of convenience, and then the absence of any other satisfactory relief. What was particularly of note to me in this judgment is the fact that the court had a good look at what constitutes a prima facie right for the purposes of satisfying the court to grant an interim interdict. Principles were restated from Webster versus Mitchell and SM versus JM, clearly set out in the judgment. You can find the full citations, so I'm not going to repeat them here. What happened in this instance? The interim interdict was granted. The applicant was successful, even though the property in question was not registered to the first respondents. And the costs of the application were to be paid jointly and severally by the first and second respondents on scale B. Notable quote can be found on page 1 of your summaries, paragraph 21 of the judgments. The court stated, as regards the prima facie right, the respondents deny that the first respondent is the beneficial owner of the property. In Webster versus Mitchell, it was held that the test is established if it is prima facie established, though open to some doubt. You do not conclusively have to prove that there is a right. It can be prima facie in nature. That was OKM versus LPM, all the way from the North Gauteng High Court under the pen of Nyati J. 1 down, 26 to go, folks, so let's get on with it. Staying in Pretoria High Court on the 1st of October under the pen of Minard AJ, we have the judgment of BTTM versus NKM, ZAGP PHC 992, and this can be found on your bundle, page 8, summary page still on page 1. Now, this was an interesting application for the division or the immediate division of the joint estate, the appointment of a liquidator, or alternatively, a decree of divorce. The application was predicated on alleged financial misconduct by the respondent, specifically the unauthorized sale or disposal of assets in the joint estate, which includes interests in a business. The respondent in this instance launched an application to strike out certain evidence from the founding affidavit and the replying affidavit on the basis that it is inadmissible hearsay as well as impermissible evidence or impermissible matter. Obviously, as in all urgent applications, one of the things that is dissected by the court per Minard AJ in this instance is the provisions of Rule 612B relating to urgency. Then also the court looked at Section 20 of the Matrimonial Property Act dealing with immediate division of the joint estate. And then in respect to the application to strike out, the court looked at Section 3.1 of the Law of Evidence Amendment Act. The outcome in this matter, the application was dismissed. The paragraphs in the founding affidavit and the replying affidavit were found to be inadmissible hearsay, and they were struck out. The applicant was to pay the costs as well as the application to strike out on an attorney and client scale, the court showing its displeasure with the cost order granted. The provisions, or the interesting quote, comes from paragraph 4 of the judgment, where the court states, per minor AJ, division of the joint estate is a natural consequence of the dissolution of a marriage in community of property. To seek such a division before the dissolution of the marriage is a drastic step. There must be strict compliance with the provisions of Section 20 of the Matrimonial Property Act. Extraordinary relief of this nature is not just for the taking, and due consideration should be given before a court is approached. The applicant unable to get their order for immediate division of the joint estate. As we know, in these types of matters, you have various forms of relief, not limited to the immediate division, but also you have your Section 16(2), where you can, in terms of the MPA, curtail the rights of the other party to transact on behalf of the joint estate. And then you also have your adjustment claims. And then let's also not forget about forfeiture. So that was BTTM versus NKM, Pretoria High Court, Minor AJ. And let's move along all the way to Mbombela. Next up, we have NLM versus GCM, ZAMP, wow, that's a lot of letters, 74. That is from the Mpumalanga High Court under the pen of Mashile J, and that is bundle page 22 and summary page 2. In this matter, the court was seized with determining a forfeiture of patrimonial benefits. And we've had some very interesting forfeiture judgments surface during 2024. And as we know, forfeiture, even though there was a lull in these types of cases, is certainly very much alive and well in our law at present. So what happened in NLM versus GCM? The defendant sought an order in their counterclaim for forfeiture of patrimonial benefits of the marriage and community of property on the basis that the plaintiff was HIV positive, and the defendant contended that this was as a result of infidelity. And on that basis, the defendant sought forfeiture. Obviously, in this matter, what was discussed, Section 9(1) of the Divorce Act being the empowering provision for a forfeiture order under the Divorce Act. And then our classic principles were restated of Vaker versus Vaker. And the court also did an interesting discussion of the concept of undue benefit, which takes us to our interesting quote, which I'll share with you a little bit later. And I'd love to hear from you in the comments, the chats, regardless of which, or depending on which platform you're watching on Facebook, LinkedIn, YouTube, or StreamYard. Please let us know what you think about the finding of the judge in this instance. Now, before we get there, I can tell you that the counterclaim was dismissed with costs. Forfeiture did not succeed. The decree of divorce obviously was granted, but an order was granted for division of the joint estate. Let me caffeinate before I go into the quotes. Two interesting quotes. The first from paragraph 10. In Vaker versus Vaker, it was held that the context and subject matter of Section 9(1) of the Act makes it abundantly clear that the legislature never intended the three factors mentioned in the sections to apply conjunctively. Then, however, the court per Mashile J goes on to paragraph 14. And for those following along in our summaries, you'll see I put the first little lines in tiny text, and then I highlighted the part which I found very, very interesting. The quote goes as follows. Clearly, when the minor child was born in 2015, it implied that his parents had been sexually active and that both had been HIV negative. If this were not the case, it would be difficult to explain why the child was free of the virus. I should perhaps also point out that even if the plaintiff had acquired the HIV as a result of engaging in sexual relationships with other people, which the court did not find was proven. This is the part that I highlighted, and I'd like to get your views on it as well, either here or on different platforms. If there is no proof that her act brought about a diminution in the joint estate, there would be no justification in ordering forfeiture against her. This is aside from the fact that such an act is possibly morally reprehensible. So the argument on the part of the defendant went, the plaintiff is HIV positive, therefore she had an affair, or therefore they had an affair, therefore there must be a forfeiture. The court then says, well, even if there was an affair, or affairs plural, if there is no diminution in the joint estate, then forfeiture cannot succeed. In other words, you need to be able to prove that there is a causal link between a diminishment in the joint estate, or diminution is perhaps the better word as the court used it. The joint estate must have suffered some sort of damage due to the alleged misconduct, obviously, in this instance. I would like to hear your views on it, either on this platform or on the WhatsApp platforms, whichever you're most comfortable with. Do you agree with the court? It is certainly a very novel view expressed by the court in this instance. I haven't seen a court refer to infidelity versus financial loss to a joint estate in the context of forfeiture. Very interesting view by the judge, certainly, and I will be very, very curious to see how this develops, whether other courts follow the principle or not. Interesting matter, NLM versus GCM, Mpumalanga High Court, Mbombela Moshile J. Moving along back to Pretoria, ISM versus RQMM, that is ZAGPPHC 1036, and this is under the pen of Neukircher J. This is on page 30 of your bundle and page 2 of your summaries for those of you following along. We again get a divorce where there is an element of forfeiture of the patrimonial benefits of the marriage. The plaintiff in this instance was the one seeking forfeiture, and essentially both parties had very, very different contentions on the reasons for the breakdown of the marriage, and obviously regarding each other's conduct. Someone's asking, will the recording be available after the session? Absolutely, it will. I will share on our various platforms the YouTube link, and you can watch it on YouTube free of charge at your own leisure. I will be sharing that link. So obviously, in terms of Section 9.1, folks, we know that the court looks at three things when deciding whether there will be an undue benefit. First off, you determine that there is a benefit. Then you have to determine whether the benefit is undue, and you look at three factors: duration of the marriage, misconduct, and then circumstances which gave rise to the breakdown of the marriage. So in this matter, the parties both had very interesting things to say about each other's conduct and misconduct, as it were, and the reasons for the breakdown of the marriage. What was dealt with in this judgment? Obviously, Section 9.1 of the Divorce Act. There's an interesting portion in the judgment where the court talks about an abuse of a Rule 43 order which was granted. The one party asked for costs to appoint an expert. An expert was never called. The court took a fairly dim view of that. And then, as in most forfeiture cases, principles were restated Vaker versus Vaker, going back to the old cases again in our jurisprudence in terms of these matters. Interesting, paragraph 34 is our quote, and before I go there, may I mention the claim for forfeiture was dismissed. Decree of divorce obviously granted. Division of the joint estate. Defendant was ordered to pay plaintiff's costs of suit. Now, the court says at paragraph 34, however, I'm of the view that although the defendant's failure to properly disclose her financial affairs at trial is to be frowned upon, it is not a factor that can be considered vis-a-vis the breakdown of the marriage relationship. Insofar as that is concerned, each party's conduct and mistrust of the other was the cause of that. And therefore, I find that each is responsible for the breakdown of the marriage. I cannot find that the defendant's dealings in cryptocurrency tipped the scales in plaintiff's favor vis-a-vis forfeiture, when viewed through the lens of his own hand in the breakdown of the marriage relationship. This being so, the plaintiff's claim for forfeiture must fail. That was very interesting judgment of Neukircher J, North Gauteng High Court, ISM versus RQMM. I haven't gone into detail of the consequences for the party who abused the Rule 43. It's very interesting to go and have a look at that. We simply don't have time to do so today. PVZ versus LVZ is next up. This is also from the North Gauteng High Court. There were several matters involved here with various case numbers under the pen of Haupt AJ 10 October 2024, and that is ZAGPPHC 1046. We are halfway. This also marks our halfway mark through part 1 of the roundup this morning. The summaries can be found on page 3 of your bundle, and the judgment can be found on page 44 of the case law bundle for those of you who purchased the resources. These were 3 unopposed divorce matters that landed before the court, and in all 3 of the matters, the parties had agreed to shared residency in respect to the minor children. The family advocate did not endorse any of the settlement agreements, as they raised concerns that shared residency might not be in the best interests of the minor children. The evidence affidavits filed lacked sufficient detail regarding the arrangements in respect to the children. When it comes to shared residency, the court had to rely on oral submissions from the family advocate, minor children, and other parties, which was contradictory to the papers. Now, what are the aspects that were dealt with? I find this a bit controversial, but nevertheless, it is what was stated in the judgment. The Children's Act does not provide any provisions that shared or co-parenting requires each party must have equal time with the minor child. It looked at B versus M, the shared residency in the best interest of the child presumption. It looked at Section 6 of the Divorce Act, that a divorce will not be granted unless the court is satisfied that adequate arrangements have been made, and then compliance with paragraph 30.6 of the Consolidated Practice Directive of Gauteng Division. The 3 matters had different outcomes. The first divorce matter, the decree of divorce, was granted. The plaintiff's attorney was disallowed fees for consultations and drafting and filing of evidence affidavits. The last 2 matters were postponed pending investigations of the family advocate. 3 quotes. I'm only going to deal with one. Paragraph 13 is, in fact, I'll deal with 2 quotes. Paragraph 13, the court says it is trite that when the interests of minor children are concerned, each matter must be decided on its own merits. The court does not function as a rubber stamp merely because the parents have reached an agreement. In the 3 matters, as in many of the other unopposed divorces that come before me, the evidence affidavits provided the barest of details to satisfy Section 6 of the Divorce Act and the Practice Directive. The evidence affidavit failed to address require detail in relation to the arrangement in respect to the children, and to place the court in a position to ascertain why the settlement agreement is in the best interest of the children concerned, including the payment of an adequate and reasonable maintenance contribution. It is not a child's responsibility, this is paragraph 69, to ensure a parent's emotional happiness. This is a terrible burden to place on a child, and this concern needs to be further investigated before a final order is granted in terms of the Divorce Act. It's also not the children's responsibility to adopt their lives and forfeit the stability, to adapt their lives and forfeit the stability and security of their established home environment to accommodate shared residency to address a parent's fear of missing out. This places the emphasis on the interest of the parent and not on the child. Very, very interesting. I see a comment is made, FAO and Pretoria do not endorse shared residency. I haven't had any issues with Joburg. FAO shared residency should not be the norm. Now, obviously, folks, shared residency is quite a contentious issue, and I think it is an issue that needs to be looked at from various points of view. And I think this judgment is going to certainly open the discourse on this aspect. Obviously, the court per helped AJ calling for heightened oversight on the part of presiding officers in respect of shared residency matters. Now, I like the comment that is made by one of our attendees today that shared residency should not be the norm. And I think essentially there are certain traps that we fall into as a result of convenience, and that is thinking that there is a particular norm. Families are not formulaic things. Children especially are not formulaic. For the parents in the room today, you will know that children have vastly different needs, one from the other, and the same child from one day to the next. Therefore, the ideal of setting in a norm to say this is good or this is not good, I think is something that we need to be very, very careful of as practitioners. Whether or not shared residency, in my view, is in the best interests of a child needs to be determined on a case-by-case basis. Obviously, there are certain very, very important considerations. Not only moving the child to satisfy the party's need to spend time with the child, but also if we look at the bonding between the parents and the child, it may also be very important for the child to have maximum contact with both parties. How that happens, unfortunately, is very, very difficult, and obviously we need to make sure that the brunt of it does not fall squarely on the child's shoulders. So certainly a very interesting judgment to go read. PVZ versus LVZ, Pretoria High Court helped AJ. Citation in full is on your screen. I look forward to engaging with our colleagues a little bit more about how this will affect the way that matters should be dealt with. Unfortunately, having to move swiftly along, we go to NAK versus TPK down in the Fair Cape, our first Cape Town judgment today. The judge is Andrews AJ. The citation is ZAWCHC 297, and the bundle page 97 and summary page 5. Just a warning for those who are very interested in PVZ versus LVZ. Get your cup of coffee ready. It is a 43-page judgment. It is quite a doozy to read through, but certainly well worth a read. Okay, so TR or NAK versus TPK, Andrews AJ, bundle page 97, summary page 5. This takes us into the realms of procedure. And this is a joinder application to join trustees of a trust, which was obviously opposed. The applicant brought a joinder to join the second and third respondent in their capacities as trustees of a trust in an ongoing divorce action between applicant and first respondent. The court looked at Rule 10.3 of the Uniform Rules of Court, looked at the principles for the test for joinder, set out in Snyder's and others versus De Jager. And then it also looked at BC versus CC, which restated the principles on the burden of proof for joinder. In BC versus CC, the applicant does not have to prove the correctness of the facts relied upon. That is meant for trial. In this instance, before I go to our notable quotes, the outcome is that the joinder was granted, and the issues of the costs of the application were reserved for future determination, obviously because the court could not make a determination on the veracity of the facts relied upon in respect of the joinder. So what the court did, plainly stated, it said to the applicant, great, join these parties, but whether there is a factual case against them, that is for determination at trial. All that needs to be shown here is that there is a case that is capable of ventilation at trial. Paragraph 21, our notable quote, it is tried that the test for joinder is whether the party to be joined has a direct and substantial legal interest in the order the court might make. In this regard, the interest will be direct or substantial if such order cannot be sustained or brought into effect without prejudicing the interests of the party. It is incumbent on the applicant to show that there is a right adversely affected or likely to be affected by the order sought. It is sufficient for the applicant to make allegations which, if proved, would entitle it to the relief. You don't have to prove the allegations at joinder stage yet. There must only be sufficient allegations which, if proved at trial, would entitle the applicant to the relief. That is NAK versus TPK, our first procedure judgment from the Western Cape High Court, Andrews AJ, on the 25th of September, coming in too late to make it to the September roundup, and thus included here. Next up, folks, we move to TR NEM versus ZDR and others, ZAGPPHC 960, Ramlal AJ, North Gauteng High Court, Pretoria, and this can be found on your bundle page 107 and summaries on page 5. This is a rescission of a divorce order. Not only is it a rescission of a divorce order, but it is a rescission of a divorce order reached by agreement pursuant to a settlement agreement. The applicant in this instance brought an application to rescind and set aside the settlement agreement and the court order on the basis that it was induced by alleged misrepresentation, dishonesty, and or fraudulent conduct. In this instance, the court did a good analysis of Rule 42.1a of the Uniform Rules, which deals with rescissions of judgment. And there were the following restatements of the requirements of fraudulent misrepresentation as set out in Ruto Flour Mills versus Moriarty's and Briet versus LC Motor. In this instance, guys, the court was not having it. The application was dismissed with costs on an attorney-client scale. Dare I say, cautiously, unsurprisingly. Paragraph 21 said, I do not deem it necessary to discuss the details of the alleged unfair, unreasonable, unjust contract terms, since the applicant has failed to show that the settlement agreement and or the order in terms of which the settlement agreement was made in an order of court must be varied or rescinded or varied. In addition, there is nothing to suggest that the court was not competent to grant the order that it did when it incorporated the settlement agreement in the granting of this order. There is nothing to suggest that the court did not consider the terms of the settlement agreement before it was made an order of court, or that the court failed to take into consideration any factors which were placed before it at the time the order was granted. Rescission fails, and the applicant pays punitive costs on an attorney-client scale, TR versus ZDR and others, Pretoria High Court, Ramlal, AJ. And then we move on to our third procedure judgment, and that is GK versus KK, our second last judgment for part one of the presentation today. And I'm going to have to pick up the pace, otherwise we're going to run over. Divorce AJ, North Gauteng High Court, GK versus KK, citation ZAGP PHC 1015, bundle, page 120, summary, page 6. It is an urgent application for separation of issues in divorce proceedings. The applicant wanted an urgent order for separation of issues, requesting a decree of divorce to facilitate his relocation to Dubai with his new partner. He claimed that the divorce was necessary to secure visas and establish a family unit in Dubai. Respondent opposed, arguing that a separation would impede her ability to secure maintenance and enforcement of court orders for the minor child. Court looked at the principles in Rule 33.4 of the Uniform Rules of Court, obviously the principles of separation of issues. Look at Section 6 of the Divorce Act, adequate arrangements for minor and dependent children, and Rule 612 of the Uniform Rules of Court, urgency. In this instance, folks, the application was dismissed with costs on an attorney and client scale. Now, that being said, there has been some discussion I saw on the groups in the last month or two regarding Rule 33.4 and separations in matters, particularly in your accrual divorces. And I must say that from what I've been able to glean from discussions and judgments that are shared, it is certainly and profoundly a mixed bag. It is not only fact dependent, it is court dependent and judge dependent. So you roll the dice and see what happens. In this instance, unfortunately for the applicant, the application was unsuccessful, dismissed with costs on an attorney-client scale. And then I turn to paragraph 21 of the judgment, which is our notable quote, which says, however, the court must consider before granting a separation of issues whether it will have an impact on the spouse's right to exercise certain remedies and enforce their claims, including claims for interim relief in terms of Uniform Rule of Court 43, forfeiture in terms of Section 9.1, and spousal maintenance. In addition, the court must consider what is fair to all parties and not just one party. While there is prejudice to the applicant in not granting the separation, the prejudice is not in fact caused by the ruling on separation. It is caused by the applicant's decision to move to Dubai. The principle of fairness requires a balancing of the interests of both parties. In this case, there is an inconvenience to the court and clear prejudice to the respondent, and O being the minor child, which the applicant has not addressed at all. Separation fails, North Gauteng High Court, divorce AJ, that is GK versus KK. Then our final judgment on procedure, VJS versus SH, and this deals with remote commissioning. You can find the judgment on page 129 of your bundle, page 6 of your summary. It came before Lekuleni J, and then once again our full Safely citation, ZAWCHC 333. Now, the facts of this matter briefly as follows. Applicant, after discovering that he's not the biological father of the child born during his marriage to respondent, seeks termination of his PRR. He also requests amendments to the birth certificate and the population register to remove his name as the child's father. The founding affidavit, interestingly in this matter, was commissioned via Zoom call remotely, and the application proceeded on an unopposed basis. So what is quite interesting in this judgment is obviously the remote commissioning thing. For those of us with international practices, that is a huge consideration. And then obviously the presumption of pater est quem nuptiae demonstrant, which is that it is assumed that a child born of a marriage is the child of the father. In this instance, the application was granted, folks, and the remote commissioning of the affidavit was accepted. Now, just before we run off and all have affidavits commissioned remotely. Please note, importantly, this is Western Cape High Court. It is uncertain whether the other divisions of the High Court will follow it. And secondly, it is also very fact specific. If your client lives down the road from your offices, perhaps your reasons for remote commissioning won't be as compelling as in this matter. So please just read the judgment and apply the principles of stare decisis and the extent to which different divisions accept judgments of other divisions before simply starting to remote commission. That caveat out of the way, the interesting quote, paragraph 36, the court says, undoubtedly the virtual e-signing of affidavits could serve as an easier, faster, and more cost-effective measure in civil litigation. The Rules Board has considered that the benefits of technology should be utilized and incorporated into the civil justice system to improve the efficiency of our courts and the processes of litigation, which would optimally utilize resources and enhance access to justice for users of the civil justice system. The modernization of the civil litigation process will provide several advantages, including reduced costs, prevention of unreasonable delays, and a quicker resolution of cases. Evidently, the ability to sign and commission affidavits through video conferencing will significantly save time, reduce travel expenses, and expedite the finalization of cases. Paragraph 38, the court says, in this case, I'm satisfied that there was substantial compliance with the Act and the regulations. So please do go and read VJS versus SH. It is a very, very interesting judgment by Lekuleni J, opening up and discussing the principles surrounding remote commissioning. And obviously, as a bonus, it is a family law case, which makes it very useful, in particular for us as family law practitioners. That takes us 1/3 of the way through the roundup, and we are halfway through on our time. So, just a reminder, for those of you who haven't picked up the course packs yet, please go to our Shopify store, pick up the course packs. Great way to support what we do to keep these presentations free, and it is also a useful tool within your practices. I have shared the link in the comments. Thank you to everyone who has purchased the course packs thus far. Next up, we go to contempt of court, and we've got a whopping 5 contempt matters. A lot of naughty respondents going on at the moment in our courts. 3 Western Cape judgments, 1 Joburg judgment, and 1 Pretoria judgment. First up, EVA versus JVA, Western Cape High Court, per Andrews AJ, and this is ZAWCHC 299, page 7 of your summaries, page 145 of your bundles. This is a contempt of court. In respect of maintenance, the applicant sought an order declaring respondent to be in contempt for failing to adhere to the maintenance provision in a deed of settlement. As always in maintenance cases, Fakie NO versus CCII principles or requirements for civil contempt were restated. Respondent in this instance was found to be in contempt, and what was quite interesting is the matter was referred to the maintenance court for an inquiry to resolve the arrears of the maintenance and the respondent's ability to contribute. Costs were granted against the respondent on party and party scale. Paragraph 46 restated what we already knew. Respondent cannot unilaterally shock. That was a shocker. The respondent cannot unilaterally change the terms of the order and pay an amount he deems appropriate. Took me an inordinate amount of time to pronounce that sentence. I'm of the view that had the respondent taken the court into his confidence fully, this court might have been in a position in the matter, similar to the matter of SS versus EB, to consider the matter differently, bearing in mind that the facts are distinguishable in that the court was seized with 2 applications in that instance. That was EVA versus JVA, and I'm going to run through these at a fairly brisk pace so we finish by 9:30. EW versus VTH, Cape Town, Parker AJ, ZAWCHC 310, and this is bundle page 165 and summary page 8. It is a contempt of court based on a parenting plan children's expenses, and the consent paper in the divorce, as well as the appropriateness of a sentence. The applicant sought an order declaring the respondent in contempt for failing to comply with a court order, which incorporated a consent paper and parenting plan. The applicant sought imprisonment, alternatively community service. In this instance, there was a history of previous contempt, and then in this instance, the court referred to the principles of Peko versus Kuruleni, and those principles were restated. This was incidentally also an urgent application, folks. The application succeeded. The respondent was declared to be in contempt of court. Respondent imposed with periodic imprisonment to be served on weekends. I love this. These provisions: weekend imprisonment, go work during the week, support your obligations, but on the weekends, no Formula One for you. You will be sitting behind bars. 30 days imprisonment, suspended on condition that there be compliance with the court order. Costs granted, attorney-client scale A. Considering all the evidence, it would not be appropriate to let the respondent off with minimal consequences. To do so would send a detrimental message to South African citizens, implying that disregard for court orders are tolerated. This would set a harmful precedent, undermining the authority of court orders and potentially discouraging vulnerable groups, including women and children, from asserting their rights to maintenance, health, and education. Parker AJ interestingly penned quite a few very, very interesting judgments from the Western Cape High Court in the last month or two. Goes on to say, paragraph 34, confidence in the legal system hinges on the meaningful exercise of the constitutional right to access courts, which necessitates that litigants have faith in the judiciary's capacity to safeguard their rights, particularly when seeking enforcement against recalcitrant individuals, whose non-compliance then jeopardizes children's access to essential maintenance, health, and educational provisions. That was EW versus VTH by Parker AJ, Western Cape High Court. Let me just lubricate my vocal cords before I lose my voice for the weekend. Might be quite interesting. Right, next up we go to Johannesburg, MAM versus MEM, ZAGPJHC 1047, ACE AJ, and that is bundle page 179, summary page 9. It was an appeal for a contempt of court order based on a divorce decree. The appellant appealed against a contempt of court ruling which found him in contempt of court for breaching Section 35 of the Children's Act. What was looked at in this matter was Fakeno versus CCII, as usual, Section 35 of the Children's Act, and then also mens rea specifically as a requirement in contempt matters, the idea of intent or negligence. The appeal in this instance was upheld and the contempt of court ruling was overturned. Paragraph 27 of the judgment says, I'm of the view that the appellant had discharged the evidentiary burden on him and that it had not been proven beyond reasonable doubt that he had been in contempt of court. Section 35 of the Children's Act makes it an offense for a person to prevent access to a child contrary to a court order. It's clear that this section is inapplicable to the circumstances of this case, and in any event, the appellant lacked the necessary mens rea to have been found guilty of any offense contemplated by this section. Now, this was a full bench constituted of Davis J, Mbongwe J, and Masibuko J. Davis J penning the judgment, Mbongwe J and Masibuko J concurring. This was North Gauteng High Court, Pretoria. I think I may have conflated two judgments. So this was DBN versus LPC. Apologies, folks. That is North Gauteng High Court full bench judgment. MAM versus MEM is the South Gauteng judgment where there was a finding of contempt of court, where the respondent was found to be in contempt of court. And that notable quote, sorry folks, I'm trying to go too fast and I am reading diagonally. MAM versus MEM, South Gauteng, contempt of court, divorce order and settlement agreement. DBN versus LPC, North Gauteng High Court, which is the appeal matter. Just distinguish the two. Very interesting judgment, also MAM versus MEM, if you want to go and have a look at it. Then we have the judgment of VL versus OCV. Person asking, is this recorded? Yes, it is recorded. You will find it on YouTube as soon as we are done, and it should also be on LinkedIn. I see you are viewing on LinkedIn. Right, VL versus OCV. I managed to have a nice chat with a colleague who's involved in the matter about it, and got some very interesting insights on this matter. VL versus OCV, ZA Western Cape High Court, 338 Safley reference. This is per Villa J in the Western Cape High Court, contempt of court for incarceration in respect of a maintenance order. The applicant wanted the respondent to be held in contempt of court for non-payment of money encapsulated in a court order, an order that the respondent be incarcerated, and that a warrant of arrest be issued, compelling the respondent to hand himself over to the police. The application was dismissed, no order as to costs. The principles looked at was facie NO, as usual, and then Section 1 of the Abolition of Civil Imprisonment Act. So paragraph 23, the court says, the applicant seeks to bring about the respondent's incarceration. Thus, the respondent needs only to put up evidence to raise a reasonable doubt to unsettle the application at the instance of the applicant. On the contrary, the usual civil onus applies with the criminal element where a coercive order is sought. Thus, a clear distinction must be drawn between punitive and coercive contempt applications. There's a very interesting judgment distinguishing between punitive judgment, i.e. incarcerate, or coercive, in other words, comply, or this will happen. Very sad quote, paragraph 33 of the judgment. That being said, at the end of the day, this is a regrettable, acrimonious, emotional, and depressing matter where one would have hoped that the applicant and respondent would have let sanity and maturity prevail to resolve their financial difficulties amicably. In these circumstances, I'm also not prepared to make a cost order against the applicant, as this will no doubt exacerbate her already strained financial position. This is VL versus OCV, which I know was also discussed quite a bit on the WhatsApp groups. That takes us to the end of contempt of court, folks. Then we have one judgment to go through in respect of marriages, and that is ZM versus PM and others, 2024 ZAGP JHC 1006, and this is Duplessis AJ from the South Gauteng High Court. Bundle page 211. And guys, can you believe we have an almost 500-page bundle today? The last case starts on page 403. So this case, page 211, summary page 11, Duplessis AJ, South Gauteng High Court. And this is a declaratory order that was sought to have a customary marriage voided or declared void. The applicant, who was the legally recognized spouse of the deceased, sought an order to void a disputed customary marriage between the deceased and the first respondent, who also claims to be married to the deceased. ZM, the applicant, contends that the first respondent has fraudulently assumed control of the deceased's estate. The case involves conflicting marriage certificates and allegations of forged documents impacting on the administration of the deceased estate and the rightful appointment of executors. Very interesting judgment looking at Section 3.1 of the Customary Marriages Act, the Recognition of Customary Marriages Act. Section 3.1 obviously being the requirements for the validity of a customary marriage. The The alleged marriage between the first respondent and the deceased was declared null and void. The applicant's attorneys were appointed as the executors of the deceased estate, and then costs were granted against the first respondent. Our notable quote in this matter: through case law, two core validity requirements for customary marriage emerged: lobola and the integration of the wife into the husband's family. Of course, customary law is not inert, and there are instances of marriages that were considered valid despite not adhering to all the rituals. In the past, courts frequently prioritized the parties' intentions. That being said, the expectation is that at least some of the customs are adhered to, even if they are modified to fit the modern and urban environment, if one asserts that a valid marriage occurred under customary law. Duplessis AJ penning this judgment of ZM versus PM in the South Gauteng High Court. Next up, our second last judgment on part 2, which we have flown through, DS versus GS, which is a Rule 43, and we are now in Rule 43 territory, guys. We have 2, 4, 6, 7 Rule 43 judgments to get through before we conclude today. So this matter, DS versus GS, ZAMPPMHC, 19 September 2024, under the pen of Bum AJ. Apologies, I heard some screaming in my office, so I've just sent someone to check whether it's good screaming or bad screaming. I hope that it's good screaming, but let's find out. This was a Rule 43 for cash maintenance, pendente lite, vehicle usage and costs, rental, etc., and a very interesting costs contribution. This matter can be found, bundle page 226 and summary page 12 per Bum AJ. The applicant sought an order pendente lite for cash maintenance of approximately 150,000 Rand per month, vehicle use and expenses, rental and cost thereof, and a contribution to legal costs of a very paltry sum of 5 million Rand, give or take a few thousand either way. What the court looked at in this judgment is the issue of prolixity of Rule 43 papers. Interesting to see, incidentally, what the Middelburg High Court does with this. As you know, friends and colleagues, there are divergent views on Rule 43 emerging now throughout South Africa. The way that Rule 43s are dealt with in terms of prolixity in Gauteng differs from Durban, differs from Cape Town, and now we also have Mpumalanga weighing in on the matter. The Rule 43 order was granted with costs, and unfortunately, there was a draft order made in order of court, so we cannot see what the amounts were that were ordered. We can see what was prayed for by the applicant, but not what was eventually ordered by the court. However, page 35 gives us a sneak peek into what the court did with the matter. The respondent, on the other hand, has conducted this litigation by hatching a bet that he might still be able to persuade the plaintiff to accede to his offer. He has failed to make a full and frank disclosure of his personal expenses, and thus I am in no position to accept his version that he cannot afford the amounts claimed by the applicant. If he is aggrieved about assets removed by the applicant, that can be addressed during the redistribution arguments. In his own words, he admitted that the family lives a luxurious life, and better still, he promised his own children, without being prompted by any of them, that their mother will continue to live the luxurious life she is used to, even after the divorce. It is telling that once the applicant pleaded redistribution, the financial stranglehold ensued. My considered view is that the contribution towards the total estimated legal costs is justified under these circumstances. Ouch. That takes us on to MIO versus AFO, which is in the Pretoria High Court, ZAGPJHC 984, and that is under the pen of Extian AJ. Those of you following along in the bundle, page 257, is the judgment, and the summary is on page 12. In MIO, the court looked at parental responsibilities and rights, contact and care, primary residence, maintenance, and medical expenses. And essentially what happened was the following. The applicant sought an order that both parties remain co-holders of PRR. Okay, crisis averted. Everyone seems okay and happy in my offices. So we can go on with a clear conscience. The applicant sought an order pendente lite that both parties remain co-holders of PRR, with minor child being primarily resident with the applicant. Applicant further sought an order pendente lite for maintenance, contribution to medical expenses, and educational costs. In this instance, the court looked at the tort versus tort, maintenance pendente lite principles, and section 7, obviously the best interests of the child standard. Right. Then what happened in this case? The Rule 43 order was granted, costs of the Rule 43 to be costs in the divorce action. The notable quote, paragraph 13, principle that applies to all matters concerning a child is the best interest of such child. Then the court goes on to say, accepted the factors set out in section 7 of the Children's Act do not exist in a vacuum. I like this, that the court says. The section 7 factors do not exist in a vacuum, as each case is different, and I am enjoined to take into account the context and facts of the case in order to determine the best interests of the minor child. The best interests do not occur in a vacuum. That is from MIO versus AFO under the pen of Extian AJ, Johannesburg High Court. Next up, we stay in Johannesburg for another judgment, but before we do that, that brings us to the end of part 2 of the presentation today. As we go into part 3, my reminder for those of you wanting to get involved in our WhatsApp groups, please go to thinklegal.co.za. You will see a lovely menu item called WhatsApp groups. By going to that menu item, you can join our commercial, litigation, and labor law WhatsApp groups, and more pertinent for the audience today, our family law WhatsApp group. We are sitting at just under 700 industry professionals on the group, including but not limited to attorneys, advocates, social workers, psychologists, mediators, financial experts, and even a few presiding officers and prosecutors. The group is a great place to share legal knowledge and to essentially sanity check with other professionals working within the realms of family law. Group is strictly moderated by myself and Nadia, to our chagrin from time to time, and the groups are closed between 7 p.m. and 7 a.m. so we can all get a little bit of peace and quiet. If you're interested in joining the groups, please go to thinklegal.co.za and go and fill in the vetting forms so we can get you added to the group and you can stay in the know on what's happening in family law in South Africa. Right, that plug out of the way, let's move on to part 3. And under part 3, we have the remainder of our Rule 43 judgments. We have 3 judgments relating to children, a judgment relating to burial rights, and a judgment relating to maintenance. We've got 20 minutes to get through these 9 judgments, or 10 judgments, 2, 4, 6, 8, 10 judgments. So I am going to be keeping an even more brisk pace. Let's see if my vocal cords can handle it. Either way, should be fun. Next up, FB versus JB, South Gauteng High Court, ZAGPJHC 1003, and Gundelfinger AJ presiding over the matter. It is a Rule 43 with aspects of maintenance and a contribution to costs. Fact simple, the applicant sought an order for maintenance pendente lite of 65K and a 1 million rand contributions to legal costs and costs of the application. Principles looked at in this judgment, incidentally for the you following along, bundle page 274 and summary page 13. The court looked at the fact that maintenance pendente lite should reflect the lifestyle and the respondents, the marital lifestyle and the respondent's ability to pay. The court should ensure equality of arms, which has become a very clear refrain in recent years in divorce proceedings, in order for the financially weaker party to litigate fairly. The fact that a claim for contribution to costs is rooted in the duty of support between spouses, stante matrimonial, matrimonial, and then finally that punitive costs are awarded only in exceptional cases of vexatious or reprehensible conduct. Rule 43 order was granted, and the respondent was to pay the costs of the application, including costs of senior counsel on scale C. Paragraph 33, the court says, the importance of equality of arms in divorce litigation should not be underestimated. Where there is a marked imbalance in the financial resource available to the parties to litigate, there is a real danger that the poorer spouse, usually the wife, will be forced to settle for less than that to which she is legally entitled, simply because she cannot afford to go to trial. On the other hand, the husband who controls the purse strings is well able to deploy financial resources in the service of his cause. That situation strikes me as inherently unfair. Let me try that again. That situation strikes me as inherently unfair. In my view, the obligation of courts to promote the constitutional rights to equal protection and benefit of the law and access to the courts requires that the courts come to the aid of spouses who are without means, to ensure that they are equipped with the necessary resources to come to court to fight for what is rightfully theirs. Rule 43 order was granted, and as I mentioned to you, it was granted with costs. Next up, we go to Pretoria for the matter of JC versus CAJC, and that is under the pen of Amin AJ, and this can be found on bundle page 289 and summary page 14. In this matter, there was a Rule 43 on an urgent basis for maintenance pendente lite, contribution to costs, primary residence, and contact and care. The applicant sought an order for interim maintenance, contribution to legal costs, and primary residence of the minor child. Now, what was dealt with in terms of this judgment? First off, as with all urgents, Rule 612, the court looked at the best interest of the child standard applied, looked at the appointment of a parenting coordinator, and it looked at Section 31 of the Children's Act, being the provisions surrounding major decisions. Now, what I'm uncertain with in this judgment, I love Geraldine. I need to just share this because that made me giggle. I hope you don't mind, Geraldine. Should the contribution towards cost order are becoming huge. I don't know what G stands for, but I do think that it's probably some form of expletive. And I agree with you. It is getting out of hand with some of these contributions. Thanks for that. Then in terms of this this JC versus CAJC judgment, the first outcome or the first order was the application for urgency dismissed. I was unable to ascertain from the context of the judgment what that means, because the application for urgency was dismissed. However, the court dealt with the Rule 43. A Rule 43 was granted interim primary residence to applicant. There was an appointment of a parenting coordinator, and then each party to bear their own costs for the litigation. So very, very interesting. We know that there have been some very interesting judgments surrounding appointments of parenting coordinators by the court. In this instance, the court did appoint a parenting coordinator, and it is worth reading the judgment to see the reasoning of the court. Paragraph 57 of the judgment, the court says, should I be wrong in my view that due consideration was given to the respondent's views about the relocation of the minor child to a new school in Pretoria, it is also my view that the Section 31(2) requirement could nevertheless be superseded by the best interest of the minor child. As upper guardian of the minor child, this court is obliged to ensure that the minor child's best interests are protected. I put that in as a notable quote, folks, because that is something you do not always, or frequently at least, see in Rule 43s, is this idea of major decisions as we have it in the Children's Act. We see it often with relocations, fights about schooling, etc. Section 31(1) obviously requiring the parent to take into consideration the views and wishes of the child, and 31(2) to take into account the views and wishes of the other party, and they must give due consideration, as the Act says, not necessarily be bound by it. Very interesting judgment. Amin AJ, JC versus CAJC, North Gauteng High Court. Next up, HVDB versus SVDB, and this is my usual time to wax lyrical about all of these really scary initials that we have to deal with as family law practitioners. I miss the days of surnames, don't you guys? But anyway, HVDB versus SVDB, and that is done by ZAGPJHC 1049 in the Johannesburg High Court, and I am now thoroughly over abbreviations right now. XT and AJ was the judge. Paragraph, bundle page 309, summary page 14. It is a Rule 43 for care and contact, supervised contact specifically. There were elements of assessment, maintenance, pendente lita, and contribution to costs. The wife sought to limit the respondent's contact with the two minor children, alleging substance and alcohol abuse. She also requested increased maintenance, pendente lita, and a contribution towards legal cost. Respondent opposed the application, denying the allegations, and filed a counter-application seeking reinstatement of his previous contact regime and the appointment of a forensic psychologist to assess the best interests of the children. Now, this is something that's very interesting, folks, the ability of the court to appoint an expert at Rule 43 stage, and or in our previous matter, the ability of the court to appoint a PC. And I'm not talking about instances where it's by agreement between the parties. Very, very interesting judgments surfacing on that, topic. So the court in this instance looked at Section 7, as always. It looked at tort versus tort. It looked at allegations of substance abuse and unpacked it quite a bit. And then the appointment of a psychologist to conduct a forensic assessment. What happened was the Rule 43 order was granted. Additionally, a psychologist was appointed to conduct a forensic assessment and provide recommendations on care, contact, and primary residence for children, and then costs of the application to be costs in the divorce. Paragraph 32 says, maintenance pendente lita is intended to be temporary and cannot be determined with the same degree of precision as would be possible in a trial where evidence is adduced. And then once again, a claim supported by reasonable and moderate details carries more weight than one which includes extravagant or extortionate demands, while the quantum does not depend on the desire of the party obligated, but must be determined in accordance with the requirements of the one to be supported and the ability of the one who must pay, tort versus tort, obviously. And then in paragraph 20, the court also looks at the best interests of the child, which I'm not going to read out for sake of time, but very interesting judgment. HVDB versus SVDB, 2467 judgments left. And I'm now going to start speaking even faster. LDK versus LDK, Johannesburg High Court, Poswa Lerotoli AJ, and that is ZAGPJHC 1051, bundle page 332, summary page 15. This is a Rule 43, care and contact, best interest of the child, supervised contact, maintenance pendente lita, failure to disclose financial information, and once again, appointment of a parenting coordinator. Interesting theme emerging here, folks, don't you think? The applicant sought to have primary residence and care over the minor children, alleging that the mom could not adequately care for them. Respondent filed a counter-application for interim maintenance of the children's primary residence to remain with her, contending that the applicant's alcohol abuse negatively impacted his ability to care for the children. The applicant failed to respond to the counter application and supplementary affidavits and did not comply with the requirement to make full financial disclosure. In this instance, the court was tasked with determining primary residence, supervised contact, appointment of a PC, the applicant's maintenance obligation of the children, and payments of costs related to the former matrimonial home. If I read the judgment correctly, and please correct me if I'm wrong, folks, there was a forensic assessment and a report done prior to this Rule 43. So the court had the benefit thereof, I believe. Please correct me if I'm wrong. Issues dealt with: practice directive, non-compliance, obviously, Section 6(2) of the Children's Act, Sections 9 and 28 of the Children's Act, best interest of the child, obviously, Section 7 of the Children's Act, tort versus tort, and then obviously provisions relating to the appointment of a parenting coordinator. Application by the applicant dismissed, costs to be reserved. Parenting coordinator appointed, maintenance pendente lite ordered. Respondent getting more success than applicant in this instance. Interesting, paragraph 9 of the judgment, the court says the applicant failed to make full financial disclosure as is required by the practice directive. Remembering, guys, this is Joburg. A party seeking or challenging an interim maintenance order in Rule 43 is obliged to make full disclosure of their financial position. Failure to do so will result in the court drawing an adverse inference against the litigant. That's an interesting kind of hidden sentence there, which we haven't really seen, in my experience, articulated. We do see a lot of skirmishes about filing of financial disclosure affidavits, but the court here stating the failure to do so will result in an adverse inference against the litigant. Furthermore, non-disclosure prevents the court from adjudicating the matter with all the facts before it. That is LDK versus LDK South, Gauteng High Court, Poswalerotoli, AJ. Next up, we go to Bloemfontein, and this is our final Rule 43 before we get into the realms of children, burial rights, and maintenance. FVN versus JWSVN, which, once again, a lot of abbreviations. ZAFS HCC 333. And then when the abbreviations start to rhyme, you know that you are properly losing your marbles. This is a Rule 43 dealing with parental responsibilities and rights, maintenance pendente lite, contribution towards legal costs, failure to make adequate disclosure, and referral to the family advocate. Mpama AJ is the presiding officer hearing the matter. Bundle page 348, summary page 17. The court looked at the Rule 43 principles, tort versus tort, and financial disclosure. Application for maintenance for minor child succeeds. Application for maintenance for the applicant does not succeed. Contribution to costs does not succeed. And there are 3 quotes here on which I've included in our bundles: 1 on maintenance pendente lite, 1 on full disclosure, and 1 on referral to family advocate. And because we do not have time, we'll have to get the bundle to see what I deem notable quotes from the judgment. Next up, folks, moving towards children. AJ versus FJ, Johannesburg High Court, Safley citation 997. And our judge in this instance, Mudal J, and bundle page 356, summary page 19. It is a relocation matter. The applicant sought the court's permission to relocate to Australia and to dispense with dad's consent. Parties were divorced, with mother having primary residence of the children and father exercising contact rights. Mom received a job offer in Australia and wished to relocate for socioeconomic reasons, including better opportunities and financial stability. Principles of Jackson versus Jackson, the bona fide reasons for the relocation principles restated. This was an urgent application, folks. Rule 612 looked at, best interest of the child looked at. The applicant was successful in the application to relocate. Respondent's counter application dismissed. And then we have 3 notable quotes from this judgment. And I'm going to start with best interest of the child. and the family counselor having taken into consideration. That can be found on paragraph 18 of the judgment. Have a look at it. Relocation principles restated. Let's state them again. Paragraph 21. It is tried that in relocation matters is to interrogate the bona fides and the reasonableness of an applicant's decision to relocate. However, the best interest of the child is still the determining factor. So, on opposition to relocation, paragraph 22, on the other hand, the court says, in this case, relocation has belatedly been conceded by the respondent father. This is one such case where the facts justify the relocation order. Opposition thereto, in my view, was completely unjustified. Strong words by the court per McDowell J. Considering the interests at play in a relocation and the implications for a party should a relocation be granted. Next up, we go to the Western Cape again. Lekuleni J, and that is CMK versus BJK. Folks, I do foresee we're going to run 10 minutes over, so please do not have me shot at dawn. CMK versus BJK, Western Cape High Court, ZAWCHC 334, bundle page 371, and summary page 20. It is an urgent application dealing with parental responsibilities and rights for the appointment of an educational psychologist to investigate the matter and a referral to the family advocate. Mom sought an order to dispense with dad's consent to appoint an educational psychologist to assess the two minor children, aged 13 and 15. Parties are divorced and their relationship obviously is acrimonious. The court had to decide whether the matter was urgent and whether appointing an educational psychologist in their children's best interests. The court found that matters involving children are inherently urgent and that the children's emotional distress, underperformance at school, and behavioral issues warranted professional intervention. My exasperation quite evident on the statement that matters surrounding children are inherently urgent. We have disparate views by different courts at this stage in that regard. A good example is the Parker AJ judgment from that very division, and other judgments throughout South Africa also saying that it's not necessarily inherently urgent, it is fact dependent. Nevertheless, the judgment looks at Rule 612, looks at Section 6.1, and it deals with the principles surrounding application to the family advocate and appointment of a psychologist. Urgency succeeds, an assessment was ordered, and the matter was referred to the family advocate. On urgency in children's matters, Lekuleni J pens the following in this judgment, paragraph 30. In my opinion, a child-centered approach should be the primary focus in any situation involving a child. Formalities and strict procedures should be secondary to their well-being, as the centrality of the child's best interests must take precedent. Interesting matter referred to the family advocate as well as to a psychologist. Interesting judgment to go read. That was CMK versus BJK. Next up, our first Eastern Cape judgment. This is the matter of JDK versus JK, ZAECQ BHC 58, and that is under the pen of Mullins AJ in the Beira High Court. And I will get the pronunciation right one of these days. Watch this space, guys. This was a Rule 43 variation application for the maintenance obligations for a major dependent child, PRR, contempt of court, and costs on an attorney-client scale. Now, this is a very interesting kind of run-up, so let's quickly go through it. Dad applied for a variation of the Rule 43 order, which required maintenance payments for the major dependent daughter who was pursuing tertiary education. Daughter had ceased her studies and had begun working, prompting the applicant to seek relief. The respondent opposed, alleging that the applicant's abusive behavior caused the daughter to abandon the studies. And the court had to look at changed circumstances. Now, what was interesting is that there was a variation granted. However, the applicant was ordered to pay the cost of the application on an attorney-client scale. And let's have a look at this. Paragraph 1 of the Rule 43 order, and I'm read from paragraph 30 in the judgment. Paragraph 1 of the Rule 43 order compels the applicant to pay $15,500 per month towards her living expenses until she has completed her tertiary studies. That is no longer applicable. That does not mean that she no longer has living expenses. Thus, while the applicant is entitled to a reduction in the monetary amount, he is not entitled to the deletion thereof. So reduction was granted, not a deletion. Paragraph 16, very sad paragraph, which brings me to costs. Although the applicant has been partially successful, he has also been partially unsuccessful. I have already dealt with his unacceptable behavior, which is deserving of censure. In addition, he comes to court with dirty hands. Despite being found guilty of being in contempt of court on 4 April 2023, he states in his affidavit that from May 2023, he unilaterally reduced the maintenance payable to 7,000 Rand. Costs I intend to make is hopefully an indication of the court's displeasure of his behavior towards his daughter. Very sad sections in the judgment if you want to read a bit more about that. 2 judgments left, final stretch, folks. Please bear with me. I see not a lot of us have run off yet, but if you do need to run off and catch up on YouTube, that is absolutely fine. But please do bear with me if you are able to. Last up, we have 2 judgments, one on maintenance, one on burial rights. Let's start on burial rights. GEM versus Triple M, and another, and that is ZAFSHC 330 WJ Bloemfontein High Court, bundle page 392, summary page 23. As we see very often, at least 2 or 3 times in previous months, once this month, burial rights are a hotbed for litigation. There was a dispute over the right to bury the deceased, the estranged spouse versus the deceased family. This is a very interesting one. The deceased wife, or the deceased's estranged wife, the applicant, sought an interdict to prevent the respondents from proceeding with the deceased funeral and burial as arranged. Deceased and the applicant were still legally married, but they were estranged, living separately for 3 years with divorce proceedings pending. The deceased had been in a long-term relationship with another woman with whom he was cohabitating. Applicant, the estranged wife, let's call her, approached the court for an interdict saying, I am the wife, I want to do the burial. Court looked at the principles of Sengadi versus Tsambo, which we looked at a bit earlier this year again, and then also Simakukhle versus Simakukhle and another, which was considered also another judgment we looked at earlier this year. The application was dismissed, breaking from a long line of cases that have vindicated the wife's rights. If you go through our roundups for the previous months, the application was dismissed, each party to pay their own costs, and the court essentially said that, you know, there's no point in letting the estranged wife, simply because they are shackled to each other by this marriage which has not yet been dissolved. There's no point in vindicating the estranged wife's rights under the circumstances. 3 quotes, one on fairness and reasonableness, one on the deceased's express wishes, and one on balancing legal rights and fairness. Not going into them to save time. Bringing up the last judgment, and let's see if we can finish it up in the next 2 or 3 minutes. CL versus ZL. It is an appeal with the judgment being penned by Villa J, the Western Cape, Kolong AJ concurring. It is an appeal against a maintenance court order in respect of a variation and substitution of maintenance obligations, looking at increased needs of minor children, parental duty of support, and judicial discretion. So, what happened? Those following along still, Those who have had their Red Bull this morning, bundle page 403, summary page 25. The appellant challenged the maintenance court's decision to increase his maintenance obligations towards his 2 minor children following an application by the respondent. The application by the respondent in the maintenance court was brought about by the children's increased needs. The parties had been divorced for 5 years already at this time, and the maintenance had been established by a settlement agreement. The respondent in the maintenance court relied on escalating education and healthcare, orthodontic costs, etc. As is very often the case, the appellant, the respondent in the maintenance court, opposed and sought a reduction. That usually happens. The one party will go and say pay more, the other party will really just oppose and come back and say, actually, you know what, they can't have an increase, I actually want a reduction. So what was looked at by the appeal court in this instance? Chapter 4 of the Maintenance Act, orders and maintenance and related orders. Subsection 6162, 16(1)(b) of Chapter 4 of the Maintenance Act. Mentz versus Simpson, the grounds for appeal were restated, and Kemp versus Kemp, best interests of the child, was referred to. The appeal was dismissed. The appellant had to pay costs on a party-and-party scale. Notable quotes from this judgment per Villa J. A court of appeal will not readily interfere with a maintenance order awarded by a lower court, being a trial court. It will only do so if there is a misdirection or irregularity. This is even more prevalent where a trial court exercises judicial discretion when weighing up what is fair, reasonable, and just, considering the peculiar circumstances of a particular case. And then paragraph 27, the best interests of the minor children remain the core focus in maintenance matters. Folks, for those of you who are still with us, thank you very much for joining me for the Family Law Roundup October 2024, presented under the ThinkLegal initiative. I have been Mervyn Vermeulen. I do remind you, please go to thinklegal.co.za, register for events, join our WhatsApp groups, purchase resources, and view past webinars. For those of you who have purchased the course packs, I really do appreciate it. It helps us to be able to feasibly take the hours required to do our research to present it to you. Thank you so much to the comments. Someone says, my first attendance at this, and I'm so impressed. Look forward to further attendance. It's great work. Thank you very much, Daryl. Appreciate it. Geraldine says she loves my interim remarks. Thank you so much, Geraldine. I try to keep it at least above the belt and not too naughty, but I do hope that it at least makes it a little bit entertaining, so that there's not too much of a slog through it. Cheryl, thank you for the feedback. Vera, thank you. Guys, thank you once again for joining us. Think Legal, as always, supported by Lawbox Practice Management Software and Vermeulen Attorneys. Fatima asks where they can access the recording. If you use the same link that you used on StreamYard, once the live stream ends, you should be able to view the recording. Alternatively, go to YouTube, type in Think Legal Official, you will see us pop up. Please do follow the channel, and all of our roundups are there, including some of our other webinars. Our Hague webinar from a few months back is there. Some of our webinars from earlier years on Rule 43, spousal maintenance, divorce, etc. Quite a lot of resources for you to watch there. So hopefully see you there. Hopefully see all of you on WhatsApp land as well. Reminder of our last family law roundup for the year, which will be on, I think it is the first Friday of December. So please do diarize that. We'll start marketing that roundup a little bit later. Vim, you can get the course pack. I'll post the link for you again on Shopify. There you go. I've posted the link again. Please click the link, go to Shopify. Otherwise, if you don't come right on Shopify, pop me an email, mervyn@vermeulenlaw.co.za. Just say, I would like the course pack. what I will do is I will send you the course back via email together with our banking details if you would prefer to do it old school. So, guys, from my side, 9 minutes over. I thought it was going to be worse with the number of cases we have to go through. Frankly, thank you for sticking around. Have a lovely Friday. All the best to all us poor family practitioners in silly season, in the run-up for December. See you guys at the next one, and I am going to be ending the stream in 5, 4, 3, 2, 1. Have a great weekend, everyone, and goodbye.